Would you please remove your hat for me? Thank you.
You're welcome.
Department of Family Protective Services versus Alicia Satterfield and Desiree Ruiz. With that, then, Ms. Dominguez, would you please begin the announcements?
Yes, sir. Corinne Dominguez for the department, Your Honor.
Taylor Gonzalez, family-based caseworker.
Carol McKetta, family-based supervisor.
Charles Weatherby, attorney for Ms. Satterfield, the mother.
Rochelle Acevedo for the father. And Judge, I apologize. I'm having issues with my video.
Alana Pearsall, attorney for the children, ready.
The parents already announced? Did I miss that?
He's talking to us.
Oh,
It's Alicia. Hello. And then I'm right.
Could you both please state your full names?
Alicia Satterfield and then Desiree Ruiz.
Thank you. I'm here today for a court-ordered services case. Have you all been able to confer on this?
No, sir.
I've talked to my client and she is agreeable with going ahead with the court-ordered services, Your Honor.
All right.
And Judge, that's the same for my client.
Okay. Then I'm going to put the attorneys in a breakout room just briefly to go over the terms and conditions of the agreement. Sounds like you all are over the big hump. You just need to finalize what specifically is going to be in this agreement. You'll be in breakout room 1. That room is open. I'll check on you in about 5 minutes. We'll be in recess until then. It is 9:24, almost 9:25, and I want to make sure I stay on schedule this morning. Were you able to iron out the terms and conditions of your agreement?
Yes, Your Honor. The services that were requested and listed in the affidavit are services that they're agreeable to. We had a request for the department to try and get a speech therapist or speech therapy for Maisie, the eldest. That may be a problem, but we're going to investigate. We don't have a provider, but FBSS will see what is available, if anything.
Is it safe to say the department would agree to make best efforts to set that up?
Yes, Your Honor.
Would that be agreeable to the parents, Mr. Weatherby and Ms. Acevedo?
Yes, Your Honor.
Your Honor.
All right, and is everything else pursuant to the agreement that Ms. Dominguez stated on the record, your understanding of the agreement, Mr. Weatherby?
Yeah.
And Ms. Acevedo?
Yes, Your Honor.
All right. Ms. Pearsall?
Yes, Judge.
Okay. All right, and for the parents, if you could unmute for me, please.
We're back.
Okay, did you both hear the agreement that Ms. Dominguez stated on the record?
Yes. Yes.
You both understand that the agreement is calling for the services that were listed in the affidavit that you were served with?
Yes, sir. Yes, sir.
And you both voluntarily agree to enter into the orders requiring you to do those services?
Yes, sir. Yes, sir.
Do you understand what's expected of you?
Yes, sir.
Have you both had the opportunity to discuss it with your attorneys?
Yes. Yes, sir.
Were either one of you forced in any way to agree to this or made any promises or inducements to get you to agree to it?
No, sir. No, sir.
Are you asking the court to approve your voluntary agreement today?
Okay. Okay.
Ms. Gonzalez, you believe that this agreement is in the best interest of the children?
I do, yes, sir.
You believe that this agreement is necessary to address the concerns that brought the children into care?
Yes, sir.
Or before the court, excuse me.
Yes, sir.
All right. Now, this is not a Texas Family's first case, correct?
It is not, Judge.
Okay. Ms. Gonzalez, do you believe these services are necessary to alleviate the effects of abuse or neglect that has occurred, or reduce the continuing danger to the physical health or safety of a child caused by an act or failure to act of the parents, and to reduce the substantial risk of abuse or neglect caused by an act or failure to act of the parents?
Yes, sir.
Okay. You believe that the children would benefit from these services.
Yes, sir.
Okay. Is everything, to your knowledge, that you had in your affidavit remain true and correct as of today?
Yes, sir.
The court will grant the petition for court-ordered services. Court takes judicial notice that the parents waived service, both Ms. Satterfield and Ms. Ruiz, on June 6th, 2024. Court finds that all those entitled to citation and notice have been duly cited and served, and that the orders as stated in the affidavit and as agreed on the record by the parties here today are in the best interest of the children, including a request and order for the department to make best efforts to procure speech therapy for Maisie, to look into that and see if it's possible. We'll be back for a compliance hearing August 21st, 2024 at 10 a.m. It's August 21st, 2024 at 10 a.m. And then the court makes the findings pursuant to Chapter 264, 203, as testified to by Ms. Gonzalez. Anything I failed to address?
No, Your Honor.
All right. Well, thank you all for working something out and talking about it. Good luck to both of you parents. And if nothing further, I'll see you all August 21st at 10 a.m. Thank you for your time and your service. All parties are dispersed. Judicial District Court of Cameron County, Texas. Mr. Barco, could you please begin the announcements?
Yes, Your Honor. Brian Bartko, Regional Attorney, representing the department for this hearing today.
Ms. Wagner?
Excuse me, Amber Wagner, Belong Adoption Specialist.
Laura Martinez, Adoption Supervisor.
You haven't announced yet. Go ahead.
Jennifer Harris, Attorney ad litem. I'm ready.
Amy Harding, Hill Country Casa Supervisor, Guardian ad litem for the child.
Lisa and Keith Franklin were the grandparents, and Xavier is currently living with us.
Lakeithia Beck from foster mom.
We're here today for a permanency review after final order. And Ms. Wagner, we're going to go over your report. Xavier at this time is 5.
He just turned 6.
Okay, well, the report says 5. Yeah, I see that he just turned 6 in May. Placed out of state with the Franklins in Colorado. Is that placement safe and appropriate, meeting his needs?
Yes, Your Honor.
Is it in his best interest to continue in that placement?
Yes, sir.
And is it the least restrictive placement possible?
Yes, Your Honor.
Permanency goals, alternative, family, relative, fictive, kin adoption?
Yes, sir.
All right, and he's been there just about 6 months?
Yes, sir.
In
July 26th will be 6 months.
Okay. Are all of his needs being met?
Yes, sir.
Medically, mentally, and educationally?
Without a doubt, yes, sir.
Okay. And he's up to date on everything?
Yes, sir.
Okay. And he still participates in therapy regularly?
Yes, sir.
Is that appropriate?
Very much so. They have been in lots of therapies that are really helping him.
Okay. How are his behaviors?
Up and down, like normal 6-year-olds, but he is learning to regulate. They are working with him really well. He has play therapy, speech therapy, so they're working with him being able to express himself better, which is getting better. I was on a visit with him night before last, and he didn't want to talk to me, but he was very clear about it. And it wasn't, sometimes I do struggle to understand him, but he was like, not doing it today.
Okay. But you believe that the therapy regimen that he's in and the other behaviors or activities that he's in, overall, everything is going well?
Oh, yes, Your Honor.
And he is still receiving Adderall?
Yes.
Is that correct? Is that review up to date?
Yes, sir. They just had the review. It was back in March, but I believe they had another one maybe in April or May. I think they upped it a little bit. I can't remember the exact date. I apologize.
Okay. And then he is going to be in the 1st grade this coming school year?
Yes, sir.
And you believe that his educational needs are being met?
Yes, sir.
Okay. What barriers, if any, at this time exist to achieving the permanency goal?
Currently, it is just the waiting period. and getting the adoptive home study out of Colorado, getting the home study out of Colorado updated, which I'm working on.
Any other specific reasonable efforts that the department or Belong have made in order to achieve the permanency goal that we haven't discussed already?
No, sir, everything's been done.
Mr. Barco, any questions for Ms. Wagner?
Think you covered most of it, Judge. Just Ms. Wagner, just to clarify the timetable that you're hoping for regarding the adoption. Do you have any estimates on the home study being completed, printed up, so at the court you can review it?
I don't. I am submitting the paperwork. We're trying to figure out exactly how to go about it, but I am not resubmitting. I am submitting the paperwork to get the adoptive home study completed. And as soon as that gets done, we'll be able to review it, get it signed, and move forward after the July 26th date.
Okay. And if you just generally have the whatever Colorado's Child Protective Services is called, are they cooperative with you in whatever your needed paperwork, information, etc.?
Oh yes, sir. They get me anything that I need, and they're really responsive.
Oh, is there anything that you are aware of that you need this court to order to assist you in either obtaining anything for the child or finishing off or progressing toward the adoption?
Not that I can think of currently.
Okay. I have nothing else, Your Honor.
Ms. Troberman? You're still muted.
Sorry about that. Amber, I know there had been at one time some confusion between like Texas and Colorado on exactly what was needed. It sounds like based on your testimony today, that's sort of been resolved, or is there anything else that we can do to help?
No, we figured it out. I just have to, I'm submitting all the paperwork. We did the kinship home study back when he was first placed. Now we have to get them to update it to an adoptive home study. So I just have to resubmit the new request to say, hey, this is where we're headed on the 26th. Can we get this, let's get this paperwork.
Okay, perfect. And with regards to the adoption assistance payments, I know there has been some discussion about that. Have you been involved in that discussion?
I did send the family the subsidy documentation paperwork that they can fill out so that we can submit for subsidy when we get closer to the adoption process.
Okay, so again, just an issue of time then, I guess.
Yes.
Okay, I have nothing further, Your Honor.
Saris?
We haven't been back to court since the judge ordered for Xavier to be placed in Colorado, correct?
I don't remember the last time we were in court, Ms. Harris. I apologize.
Okay, so he's made the transition to Colorado, okay?
Fantastically. I saw him in, May, I think is when I went up there, and he was doing fantastically. I saw him at school. He was doing really well at school, bonded with the classmates. Lisa was there that day. He's doing really well at school. He's doing really well up there. I hear nothing but good things. All of his reports, everything from Lisa, he's doing so well up there.
So other than the time period needed to wait for the adoption, is there anything that Xavier or the family is needing in the meantime?
Not that I can think of currently. I think we've got everything covered. I think we're just kind of waiting for the time period to run.
And you feel that Xavier is well settled and bonded with the Franklins?
Very much so, yes.
And so pursuing adoption as soon as possible would be in his best interest?
Yes, ma'am.
Has a HUSIG been requested, or will that requirement be waived as family members?
It's waived because they're family.
Is there any other paperwork that you need to have in place for the adoption to occur?
Just the general adoption paperwork, the adoption petition, all that stuff. Just the stuff that I have to wait for the 26th before I can start really hitting it and getting those things done.
No further questions, Judge.
I'm going to add on that and ask a real quick question, Ms. Wagner. Have you already requested redaction?
Yes, sir.
Okay. Any other questions or any other witnesses, Mr. Barco?
No, Your Honor.
All right. Anything else from you, Ms. Troberman?
I don't believe so.
Ms. Harris, report.
Your Honor, he's doing well. I have not personally gotten out to Colorado to see him. I was supposed to a couple of weeks ago and had a family emergency, but I will get out soon. He's doing great. Like Miss Wagner said, he's not too interested in spending any time on the camera to see any of us or talk to any of us. But being able to sit and watch him go about his life, he's clearly happy and they're meeting his needs.
Thank you. Casa?
Thank you, Judge. I did have an opportunity to visit Xavier in his home in Colorado on a Saturday in May. I got to see him engage with both of his grandparents and his older sister. The home is very comfortable and loving, lots of affection, some sibling dynamics that they continue to work through, as Mila and Xavier were used to being only children, but they seem to be handling that like pro parents. We got to spend a lot of time outside and see him redirected, and I have no concerns about his safety or well-being. They are meeting all of his needs. They have been very diligent in getting him to diagnostic appointments so that he has a accurate and appropriate diagnosis of being on the autism spectrum. So they are working through that and getting him all of his services and additional support for that. He did have his last medication review on May 26th. He is taking 20 milligrams of Adderall in the morning for ADHD. And then I don't know if they're continuing to give it to him during the summer, but during the school year, he was getting a supplemental 5 milligrams in the afternoon to help with his therapies and routines then. And those seem to be appropriate. His behaviors, they continue to work on, but are not anything out of normal for a child with ADHD and on the autism spectrum and 6 years old. He's got a lot of energy and they do a lot of activities to keep him going. Casa is very much looking forward to the adoption. We believe that's in his best interest and hope that we can get that scheduled just as soon as all of the documents and legal requirements are in place.
Thank you. And for the purpose of the permanency review after final order, the court finds that the permanency goal of relative adoption is in Xavier's best interest, that he's up to date on all of his checkups, and the placement is safe, appropriate, meeting his needs, and in his best interest to continue. Court finds that placement with the Franklins is least restrictive placement possible, and his educational needs are being met. The therapy is appropriate. And the court makes the finding that his medication review is up to date. Court finds that the only barrier to the permanency goal at this time is the waiting period and the home study from Colorado that needs to be processed. But we'll find that the department has made reasonable efforts in working on that home study and waiving the hashtag and requesting redaction and just moving towards that 6-month period. Our next hearing is going to be a permanency review after final order for November 13th, 2024 at 10:30. November 13th, 2024 at 10:30. Glad to hear things are going as well as they are. It's been 5 months since we've all been in court together, so I do appreciate the fact that so much progress has been made since that time, and Xavier's in good hands, and all seems to be going well. So thank you all for your time and your service. I'll see you November 13th at 10:30, and nothing further on
Your Honor,
projects.
can I ask one quick question that I should have asked before you were done with this, but while I have us all on here, and it may be, I think Amber is the person I need to direct it at, but we had talked a lot about some reimbursement for summer activities that Belong was going to assist with. Does anybody know what the status of that is? I just wanted to ask while we were all on here.
I do know they got a reimbursement for one of the camps. I believe I'm looking, I have to send the receipts if we haven't gotten them yet over to have the other 2 reimbursed. But I do know that the first camp from back in earlier this month, I believe, has been reimbursed. But I'm not sure the status of the other 2 with the receipts, but I'll check on that today.
Thank you so much. Sorry about that, Your Honor. I should have asked while she was on the stand.
No problem. Sounds like it's being handled. All right, thank you. All parties are excused. In the 451st Judicial District Court of Kendall County, Texas. Mr. Bartko, would you please begin the announcements?
Yes, Your Honor. Brian Bartko, Regional Attorney representing the department for today's hearing.
Shelley Nix, Belong Permanency Specialist.
Ashley Crouch, Belong Permanency Supervisor.
Carol Collins, attorney ad litem for Carissa.
All right, Miss Nix, when we were here in December, Carissa was in the TLP at Travis County Settlement. She's still there?
No, Your Honor. She stayed there until February the 29th, and after expressing her discontent and wanting to go to another SIL, which we were in the process of helping her with, she decided to leave care. So on February 29th, a coworker and I went to Austin and packed her up and moved her to a relative's home in San Antonio.
All right. Have you heard from her since then?
I have not heard from her. She did not contact me directly. I know a little while back she was reaching out to her youth specialist, Miss Garcia, asking about the possibility of returning to care, and Miss Garcia was attempting to get her to complete the required paperwork, and then Miss Garcia left the agency, and I have not heard anything from Miss Villalobos.
All right. Ms. Collins, have you heard anything from her?
Yes, Your Honor. I have a little more of an update. I talked to Miss Nix a couple of days ago, and then that same day I called Carissa, and I think what happened is, according to Miss Nix, she went with her aunt and uncle when she left Selma home. But she is now living with her mom. We all know the history of that situation, but she said she's living with her mom for the past 2 or 3 weeks. And she says, quote unquote, things are going great. She also said, I am living my best life. And she is keeping her options open for the future. She wants to get her own place in July. She said if she doesn't, she would come back into care. But we all know that that's probably up and down. She is working at Thrive, which is a preschool, and she does have her own car now while Ms. Nix was involved in the case. So who knows? She says she's living her best life. And Carissa's up and down. We all know that she can get discontent with rules and with wherever she's living. But all in all, she's come a long way since the days of removal. And she has a job. She has a car. She's apparently made amends with her family. And so we'll see if she wants to come back into care. And my guess is she'll continue on with her life in some form or fashion with her relatives and working. And so that's pretty much it. She says she's doing great.
All right. Well, then I had Mr. Barco, do you have any questions about anything?
No, Judge. I think the ad litem and Ms. Nix both, stated the situation. The permanency report has been filed, and maybe just a quick question with Ms. Nix. Do you believe that? Oh, thank you, Judge. Ms. Nix, do you believe that Carissa knows her options for benefits or help from you or the department?
Yes, she understands. She stayed in extended care for about a year. So she's aware of her benefits. She's aware of her ability to return to care, that she just needs to reach out to me or Miss Collins, who would certainly get her in touch with me to help her access if she wants to return to extended foster care. But yeah, she knows how to access her benefits.
Okay. Nothing else from me, right, Your Honor.
Thank you, Mr. Barco. Then, pursuant to the order court signed on from a hearing on December 20th, signed December 29th, 2023, that order states that if she were to leave extended foster care prior to the date for the next scheduled foster care review, which was today, and she left on February 29th, that she would be approved for the maximum trial independence period for 1 year, I believe. And then that review proceeding would have been today. So Ms. Nix testified February 29th was the date she left care, and the court will make a finding that she did leave care on February the 29th, 2024, and continue that order regarding the extended services. And I'm not going to set another hearing on this case. We'll just leave it off the docket. But if she reaches out and lets you, Ms. Collins, or you, Ms. Nix, or anybody else know that she wants to return to care, well, obviously we would be fine with that. But I think, when this case started, TMC was granted on April the 29th of 2020. So, well, 4 years into it, she's already spent a year in extended foster care. When this case started, there was a lot of discombobulation in that home. And I feel like maybe the purpose has been served. Hopefully we don't hear back from her again. Hopefully she is living her best life. Hopefully she is things are going great, and that she can just move on into adulthood, having that repaired relationship with her family. But I'm just glad we were able to be there for her during the time when things weren't so rosy. Anything further from anyone else?
No, Your Honor.
Okay. Well, thank you all for your time and your service, Ms. Collins. I can't remember how long you've been on this case, Ms. Nix.
Just since December, Your Honor.
Okay, that's what I thought. So Ms. Collins is our veteran here. She's been
Yeah,
involved the entire time. Ms. Crouch has been here for a while too, but I think Ms. Collins takes the cake on it. Besides me too. So thank you for everything you did over the years for the girls.
Sure. If we hear from her and need another hearing, we'll reach out.
Okay. All right. Then all parties are excused, and there'll be no further hearings.
Thank you.
Thank you.
Thank you,
Family
Judge.
Protective Services
Thank
versus
you, Your
Virginia Smith and Cody Scribner in the 451st Judicial District Court of Kendall County, Texas. Mr. Bartko, would you please begin the announcements?
Yes, thank you, Your Honor. Brian Bartko, Regional Attorney representing the department for this hearing.
Carol McKetta, Family-Based Supervisor. Laura Miller, Family-Based Caseworker.
Richard Saldivar, attorney for the mother. Ms. Smith, will you unmute and announce, please?
I'm unmuted.
Okay, could you state your name, please, for the record? You say it one more time, you broke up.
Virginia Smith.
Thank you.
I'm Marco Cabrera, attorney for Father Mr. Cody Scribner. He's present. Mr. Scribner, could you announce yourself as well?
Yes, sir. Cody Scribner, present.
Maureen Yanis, attorney ad litem for the children.
I've reviewed the report, Ms. Miller, and I know there's some specifics in here, but it looks like for the most part, parents are in compliance, and you're asking to continue the case so they can continue to engage and take advantage of the services.
Yes, Judge. We're going to ask to dismiss at this time.
Okay. Tell me why you think it's in the best interest of the children to dismiss the case at this time.
Both parents have continued to work services through traditional family-based services. Virginia's been doing very well. She's engaged and has made substantial progress in her PAT services. She's engaged in individual and chemical dependency counseling, and she's continuing to randomly drug test for the department. Carson, the youngest child, has been assessed by the PAT professional, and there were no concerns for delays. And I continue to check in with Cody's probation office, and he's continuing to meet the stipulation of his probation.
Okay, so you believe that any remaining issues will be appropriately addressed without court intervention?
Yes, sir.
And you believe that's in the best interest of the children?
Yes, sir.
All right. Mr. Bartko, any questions for Ms. Miller?
Just one or two. Ms. Miller, have you had a chance to talk to the attorneys and the parents prior to today regarding your proposal?
I know we did have a family group conference about 2 days ago. Mother's attorney was made aware that we were looking to dismiss, and we discussed her progress in that meeting. I was able to communicate through email to the father's attorney about dismissal and where he stands in his progress. And I was able to communicate this morning to Ms. Maureen Yanis.
Okay, and just to clarify, just to make sure everyone knows, you still believe that the parents still need to work with you regarding some services, is that right?
Yes, definitely. I would like to see them through to the end and get full recommendation from all the professionals on the case.
And it's your understanding or assessment that you don't need the court to oversee the rest of the progress for the parents on their service plan?
Yes, sir. Both parents have agreed, and they've been open and honest and worked very hard throughout this case.
Okay, I'll pass the witness, Judge.
Mr. Saldivar?
I have no questions, Your Honor.
Mr. Cabrera?
I have no questions either.
Ms. Yanis?
Thank you, Judge. Ms. Miller, the parents continue to have a huge amount of support from their parents. Is that correct?
Yes.
And you expect that that will continue, which would facilitate the parents being able to continue under FDSS. True?
Yes, definitely.
That's all I have.
All right. Anything else that you want to add, Ms. Yanis, that I haven't heard yet?
Judge, these kids are so fortunate. They have parents who understand and are embracing, these programs that are being made available to them. I know that they both appreciate that grandparents are playing a big part in this, and they're all working together. I think it's in the children's best interest that we just let them proceed on their own.
All right, thank you, Ms. Yonis. Anything further from anyone else?
No, Your Honor.
No, Your Honor.
Okay, I think I've heard sufficient evidence that further court intervention in this case at this time is not needed. I'm going to grant the department/belongs request, or I guess just the department's request to dismiss the court-ordered services. And that is Ms. Smith and Mr. Scribner making that decision based on the information that's been presented here today, that not only have you both engaged and picked up on a lot of what you needed, which I'm proud of you both for, good job, but that you have made it clear and represented that you're going to continue to work these services and these programs without the need for coming back to court. That's obviously where we want you to be. And obviously we want you to eventually be to a point where there's nobody involved in your life. You're just doing these things on your own with your children. So this is the first step back into that direction. From what you've done so far, obviously you can do it. You just have to stick with it and continue to make progress. And I mean it in the nicest way possible when I say I don't want to see you back here in front of me in court. So good luck to you both. Give a little round of applause for making it through this part. Just remember, you still have some work to do. You're welcome. Just keep doing the work, and this will all be a memory at some point. Thank you all for your time and your service. And if nothing further, all parties are excused. Motion's granted. Case is dismissed. There'll be no further hearings.
Thank you, sir.
You're welcome.
Thank you, Your Honor.
Judicial District Court of
You're
Gillespie County, Texas. The court is streaming via YouTube and Zoom from the courthouse in Kendall County, Texas. Are there any objections?
No, Your Honor.
No, Your Honor.
No objection.
Ms. Surratt, with that, would you please begin the announcements?
Michelle Surratt, attorney for the department, present, ready to proceed. I'll allow Belong to introduce themselves.
Katarina Lewis, Belong Permanency Specialist.
Ashley Crouch, Belong Permanency Supervisor.
Irene Acosta, attorney for the respondent mother.
David Nelson, Casa Guardian ad litem.
Amy Harding, Hill Country Casa Supervisor.
Kendra Sims, attorney ad litem for the children.
I don't know if I'm next. Jody Johnson, paternal grandmother.
Ms. Slaughter, can you unmute and announce, please?
Ambria Slaughter, I'm the aunt.
Thank you. All right, so we're missing both parents. There's Mr. Rudkin. Miss Lewis, did you have any contact with either parent before?
Mr. Slaughter is currently in inpatient, so I'm not sure if he's going to be getting on. I know he knew about it. I've spoken with Miss Slaughter, but I called her earlier and she did not answer me.
Your Honor, I'll reach out to her.
Thank you, Mr. Acosta.
Kurt Redkin for father, Jonathan Slaughter.
We're here today for a status hearing. At this point, we do not have either parent present, but I did review Ms. Lewis's status report. Just going to go over the high points here. Children are placed with family or kinship in Travis County. Is that placement safe and appropriate, meeting their needs?
Yes, however, that is going to be changing by Monday. They're going to be placed with their paternal aunt and uncle in Allen, Texas.
What county is that?
I am unsure what county.
Collin County, Your Honor.
Yeah, it's Collin County.
Thank you. I apologize.
It's all right. And they're going to be placed there Monday,
That is our plan. Yes.
24th.
Yes.
All right. There's no Indian Child Heritage in this case, is there?
No.
All right. At this time, is their current placement safe and appropriate, meeting their needs?
Yes, they are actually currently on a visit with their paternal grandmother and grandpa. But yes, it is.
But it's in their best interest to move with the aunt and uncle in Collin County.
Yes.
Is that the least restricted placement available?
Yes.
I noticed in the report that they've had, they need a medical and a dental checkup. Is that still the case?
They were able to get their medical completed on June 6th. And then they do need a dental, yes, and that is in the process of being scheduled, and the new placement is aware of that.
Are there any known dental concerns, anything that's going on right now that?
I don't believe so. I have not been notified of that.
Okay. Have they been evaluated? Let's see. Well, I guess they're too old. Have either of them had a CANS?
They have not had a CANS or a psychological yet. However, those are already scheduled, and are coming up next week.
Okay. Have you spoken to the future caregivers about school? Do we know where they're going to be going to school, and is that all set up?
Yes, we have talked about school. I'm not sure the exact school that they'll be going to, but I will get that information, and yes, they will be going to school there.
Okay. All right. And then, like I said, we don't have either parent here. So have the parents been participating in their visitations?
Yes.
Okay. Now, how long has Mr. Slaughter been at rehab?
He has been in rehab about a week now.
And where's mom? Where's she living?
I don't have an address for her, but I believe she is in the Fredericksburg area.
Are the visitation, well, before dad went to rehab, were the visitations appropriate?
Yes, they were.
All right, she's here now. All right, and are you asking to continue the current visitation schedules?
Yes, I am. I do know the kids are going to be a little farther now. So I am asking that we all come together and be able to find a solution for at least once a month, maybe, or if the parents are able to get up there bi-weekly, I'm okay with that and keeping it the same.
And as long as father is an inpatient, is that virtual only, or have you been made aware of some sort of in-person visitation he could attend?
I have not been made aware of any in person, but I'm hopeful that we can get virtual set up so they can have virtual contact with him while he's there. He's in San Angelo, so that's pretty far from Dallas.
Yes, it's quite a drive. Okay. You were all able to hold a family group conference?
Yes.
And at that family group conference, did the parents participate?
Yes, they did.
The parents review and sign the family plans of service?
Yes. Miss Slaughter was able to sign it while she was there. Mr. Slaughter was virtual, so I have sent him a copy of it for him to review and sign.
Those family plans of service were filed?
Yes.
And do both parents have a copy of it?
Yes.
Are the services on the family plan of service narrowly tailored to address the concerns that brought the children into care?
Yes, they are.
You believe they're in the best interest of the children?
I do.
Can you briefly set forth the services that you're asking both parents to do?
Yes, I can. I am asking both parents to continue their visitation with their children. I'm asking them to engage in a psychological evaluation along with participating in individual counseling, random drug testing. I'm asking for Ms. Slaughter to complete her OZAR assessment tomorrow that is scheduled. Mr. Slaughter has already completed his drug and alcohol assessment and is now an inpatient. So we would just ask that after he's done with that to follow any recommendations for outpatient or anything like that as well.
Parents are cooperating with you?
Yes.
As of today, has either parent fully addressed the concerns that brought the children into care?
No.
As of today, is it safe to return the children to either parent?
No.
Are you asking that the children remain in the temporary management conservatorship of the department / belong?
Yes, I am.
Ms. Surratt, any questions for Ms. Lewis?
No, Your Honor.
Miss, before I go into your cross, Miss Acosta, Miss Slaughter, are you there? It says Ashley's iPhone. Can you hear me? Can you unmute, please? *6. I can hear you now. Could you state your name for the record, please?
Ashley Slaughter.
And your attorney, Ms. Acosta, is going to ask some questions of Ms. Lewis, who is the permanency specialist for Belong. Okay?
Okay.
All right. Go ahead, Ms. Acosta.
Thank you. Ms. Lewis, what services are you requesting of Ms. Slaughter?
Yes, I'm requesting her to complete her drug and alcohol assessment. I'm asking her to follow all recommendations from that, whether it be inpatient, outpatient, any of that. I'm also asking her to complete a psychological evaluation, engage in individual counseling, and random drug testing.
Okay, of those services, which referrals have been sent out?
An OZAR has been sent out, a individual counseling has been sent out. Oh my goodness. A psychological evaluation has also been sent out. And then I will drug test her as well.
Okay, and does she have all of the information for the providers?
Yes, and she has communicated with them as well.
Okay, which services has she set up so far?
She was communicating with the individual counselor to get a session set up, so I'll follow up on that. And then tomorrow she actually has her OZAR at 10:30, I believe.
Okay, and has her psychological been scheduled?
I do not believe it's been scheduled, but I'll follow up with that referral and see.
Okay, and of those services, which is the most important?
I believe her OZAR drug and alcohol assessment. Those are our main concerns, is the drugs.
Okay, with regard to the visit, how far are the kids going to be from her now?
About 4.5 hours.
Okay, given the distance, would it be possible with her with more compliance as she continues with her services to set up additional virtual visits in between her in-person visits to have increased contact with the kids?
Yes, I wouldn't be opposed to that.
Okay. Is there anything else that she needs to be doing right now?
Not at this time, just continue contact with me and we'll get her in her services.
Okay, thank you. I'll pass the witness, Judge.
Mr. Rookin?
How is Mr. Slaughter doing in his rehab so far? Do you have any progress reports from rehab?
I do not yet. I'm working on getting a counselor's information. However, I do know he called me yesterday and he sounded like he was doing well.
Good. And do you know when he'll be completed, if he does everything like he's supposed to do, the estimated completion date?
I do not yet, but I am thinking probably the end of July probably sounds about right.
So has he done everything he's been asked to do so far in his family plan of service?
Yes.
Any criticisms or shortcomings you think you need to bring up right now?
Not at this time, no.
Okay. Pass witness.
Ms. Sims?
I don't have any questions, Your Honor.
Any redirect to Ms. Surratt?
No, Your Honor.
Any other witnesses or evidence?
No, Your Honor.
All right. Ms. Acosta, anything else?
No, Your Honor, nothing from me.
Mr. Rudkin, Ms. Sims, anything else?
No, Your Honor.
Okay. Let me hear your report, if you would, Ms. Sims, please.
Yes, Your Honor. So yesterday, Mr. Nelson and I got to FaceTime with the kids up in Dallas. They're with their paternal grandparents, and they have been kind of there for an extended visit. The kids both seemed like they were doing well. They were excited to be there. The grandparents put them in camps. Emma's going to art camp. Clayton's going to soccer camp. Next week, they're going to go to horse camp with their cousins. The grandparents report they've adjusted well. They're getting on a schedule. I don't have any concerns with that. I'm very happy that the aunt and uncle are going to take placement of the kids. This all kind of just happened. I haven't really gotten to visit with them, but I don't have any concerns. The grandparents are right there to help. So I'm very pleased right now with how everything's going.
Thank you, Ms. Sims. Mr. Nelson?
Like you said, we met with the kids yesterday. I was very pleased. They looked happy. Emma likes to swim and dive, apparently, and she likes Yahtzee, so be prepared for Yahtzee. Clayton, John enjoys playing soccer and seemed happy. They seemed happy where they were, and I'm very pleased with the placement with the aunt and uncle.
All right, thank you. Okay, then for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. Court finds that Mr. Slaughter at this point in time is attending inpatient and is not present today. The court will excuse that. Court finds that the placement of the children will be changing to Allen, Texas, and Collin County, effective June 24th, 2024. At this time, the current placement is safe and appropriate, meeting the needs of the children, but it's in their best interest, based on the testimony, to move to the aunt and uncle's home, so the court will order that be done. Court finds that the current placement is the least restricted placement available, and that by the testimony and reports, the placement with the aunt and uncle will also be least restrictive. Court finds that the children are up to date on their medical, but they need a dental. I'm going to order the long follow-up with the placement, make sure we get that scheduled. Court makes a finding that the parties have already scheduled the children for cans and psychologicals. Court finds that their educational needs are being addressed. And I'm going to continue the current visitation schedules, but authorize the parties as appropriate based on engagement of the parents and the ability to do so, to start increasing, whether it be virtually or in person, as the parties agree. If you can't agree, then we'll come back into court and we'll talk about it, or we can have a conference call, whatever it takes to get that done. Court finds the parties held a family group conference. The parents participated. The parents participated in the creation of the plan. Mom has reviewed her plan and signed it. Dad is still reviewing. Court finds that both parents have a copy of their family plan of service. Court finds the plans are narrowly tailored to address the concerns that brought the children into care, and that it's in the best interest of the children to make those family plans of service orders of the court. Court finds that the parents are cooperating with belong. As of today, it's not safe to return the children to either parent, and as of today, neither parent has fully addressed the concerns that brought the children into care. Court will turn the family plans of service that are on file with the court into orders. Our next hearing will be September 24th, 2024 at 11. September 24th, 2024 at 11. Now, I know he's not here to hear it, but obviously you can share this information with him, Mr. Rudkin, but you are Ms. Slaughter, so I want to make sure you understand the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to further restriction as they are now, or termination. Everything is set and in place right now, Ms. Slaughter, for you to be reunified with your child, but you have to do the work. You can't just check the boxes off the list. You have to engage in these services and make sure that you address these concerns and that you use what you learn to improve your child's lives, your parenting experience, and to reunify your family. The clock is ticking. It will run out. You cannot put this stuff off, and you can't delay it, and you can't look at it like, oh, I'll do that next week. You've got to remember that your children are young. They're 6 and 12. So a month of their life is a lot longer than a month of yours. Okay? Things are going to move fast. So adjust with it and make sure that you stay in touch with Ms. Lewis and your attorney. And I think that's everything. Ms. Surratt, is there anything I failed to address?
No, Your Honor.
Okay. Thank you all for your time and your service. Thank you to the family for doing what you're doing. And if nothing further, I'll see you September 24th at 11 a.m. All parties are excused.
Thank you.
Thank you.
Welcome.
Thank you, Your Honor.
District Court of Kendall County. Court is on YouTube, but is actually streaming from Kendall County. Mr. McKeska, would you please begin the announcements?
Yes, Judge. Frank McKeska, attorney for the department. Ms. Nix.
Shelley Nix, belong permanency specialist.
Ashley Crouch, belong permanency supervisor.
Richard Sauter, attorney for the child. Ready?
Deborah Fuller, attorney for the mother. Nicole Gonzalez, is she supposed to be present? Is she there?
She's here. She's here by phone.
Okay, thank you.
Ms. Gonzalez, can you announce for the record, please?
I'm Nicole Gonzalez.
Charles Weatherby, attorney for the father, Derek Doogie. Mr. Doogie, could you announce you're present?
You're muted.
Derek Doogie. Derek Doogie.
We heard you. Thank you. Is there anybody else that needs to announce?
Amy Harding.
Kristen Weber, Hill Country.
Ms. Harding, why don't you try again?
Amy Harding, Hill Country Casa, guardian ad litem for the child.
Okay, we're here today for a final trial. Mr. McKeska, how do the parties wish to proceed?
Yes, Judge. We do have an agreement with regard to moving forward with Ms. Gonzalez. I haven't had a chance to speak with Mr. Weatherby regarding his client, because I know there's been some long periods of no contact with him. So if we could just have a moment to speak in a breakout room, we might be able to reach an agreement with him as well.
Okay. Do you want all the attorneys in one room?
Maybe, yeah, just, yes.
Mr. McKeska, after conferring, have the parties been able to reach any further agreements?
Yes, Judge, we have.
All right. Go ahead.
So, Judge, with regard to the respondent mother, Nicole Marie Gonzalez, we've been able to reach the following agreement, and it is encapsulated in a written Rule 11 agreement that has been signed off by the parties and the foster parents that I believe Ms. Fuller just recently, within the last few minutes, has filed. But it reads, and I'm going to read it in its totality into the record. So on the 19th of June, 2024, the parties agreed to the following. Number one, the parties agreed that the Rule 11 agreement is binding on the Department of Family and Protective Services. The attorney ad litem for the child, the mother, Nicole Marie Gonzalez, in Hill Country Casa. Number two, the above referenced parties agree that this Rule 11 agreement is in the best interest of the child. Number three, the mother, Nicole Marie Gonzalez, agrees to execute an affidavit of voluntary relinquishment as to Cassius. Number four, at the final hearing, the department shall request that termination of the mother's rights be based solely on her affidavit of voluntary relinquishment and the best interest of the child. Number five, the department shall continue to seek an adoptive placement for the child that is willing to agree to photos and updates by email 4 times a year, as long as Nicole Marie Gonzalez provides a valid email address and maintain contact with biological relatives. Number seven, the department shall provide the mother, Nicole Marie Gonzalez, with a 2-hour supervised goodbye visit with the child. Number eight, the department shall seek adoptive placement with the present foster home, Brandy and Robert Quinn. And number nine, the child shall not be placed in the home of Stephen and Christina Boy at any point. With regard to the father, Mr. Dogie, we have reached an agreement in which Mr. Dogie will stipulate to the elements of the termination grounds under section 161.001B1N and O of the Texas Family Code, and that termination of the parent-child relationship based on those grounds is in the best interest of the child. That's it.
Okay. Are you all prepared to move forward today?
Yes, Judge, we are.
Okay. Any housekeeping issues we need to take up?
Judge, I do have a list of exhibits that I would like to introduce into evidence. So if you'd enable the share screen function, I can go through those and see if we can just get them all admitted up front.
Okay. Before we get into too much of that, let me just, as far as the Rule 11 agreement is concerned, are there any objections to the Rule 11 agreement as stated by Mr. McKeska on the record?
No, Your Honor.
No, Your Honor.
Mr. Weatherby? You're muted.
No objection, Your Honor.
Okay. Ms. Gonzalez, you can hear me?
Yes, sir.
You heard the agreement that Mr. McKeska read off into the record?
Yes, sir.
Is that your understanding of the agreement?
Yes.
Did you have a chance to discuss it with your attorney?
Yes, sir.
Do you understand what's expected of you?
Yes, sir.
And do you understand what the results of the agreement will be?
Yes, sir.
Were you forced to enter into that agreement in any way?
No.
Were you made any promises or inducements to get you to agree to it?
No, sir.
Are you asking the court to approve your voluntary agreement to the Rule 11?
Yes, sir.
Are you asking the court to allow the department to proceed pursuant to the agreement today?
Yes, sir.
All right. Thank you, Ms. Gonzalez. Mr. Weatherby, Mr. McKeska represented to the court what your client has stipulated to. Was that your understanding of the stipulation?
Yes, Your Honor.
All right. Anybody else have any objections to the stipulation of Mr. Juji in this case?
No, Your Honor.
No, Your Honor.
Okay, Mr. Duji, can you please unmute? You've had an opportunity to discuss this case with your attorney.
Yes, sir.
All right, and he's explained what options are available to you.
Yes, sir.
And you have made a decision to proceed with the stipulation that Mr. McKeska stated on the record in this trial.
Yes, sir.
Is that your voluntary decision?
Yes, sir.
Were you forced in any way to make this decision or made any promises or inducements to get you to make this decision?
No, sir.
Okay, thank you, Mr. Duji. All right, then. Screen share is enabled if you want to pull up those exhibits, Mr. McKeska.
Thank you, Judge. Everything's been pre-marked, so I'll go through them one by one. Number one is a certified copy of the return of citation for the respondent mother, Ms. Gonzalez. Number two is a certified copy of the waiver of service from the respondent father, Mr. Duji. Number three is a certified copy of the court of continuing jurisdiction letter received from the Department of State Health Services. It's also a certified copy. Number four is a certified copy of the return certificate of paternity registry search. Number five is a copy of the temporary order from the following the adversary hearing in this case. Judge, number six is a copy of the mother's family plan of service, but I'm not asking to admit that today. I had not taken it out whenever I made some changes to these exhibits earlier today. So I'm not, just again for clarity, not asking to admit petitioner 6. I will remove that from the list of exhibits whenever they're provided to the court reporter at the end of this hearing. Petitioner 7 is a certified copy of the family plan of service for the respondent father, Mr. Dogie, or Mr. Doji, I apologize. Number 8 is a certified copy of the status hearing order from this case. Number 9 is a certified copy of the initial permanency hearing order before final order from this case. Number 10 is a certified copy of the permanency hearing order before final order from this case. Number 11 is a certified copy of the order adjudicating parentage, establishing the parent-child relationship between the child, Cassius, the respondent father, Derek Dean Doji. And number 12 is a copy of file stamp copy of the affidavit of voluntary relinquishment of parental rights executed by the respondent mother, Nicole Marie Gonzalez, that was filed with this court earlier this morning. It shows that it was filed on or accepted at midnight on the 20th. And that is all of the exhibits the department wishes to admit, Judge.
Anything else we need to take up before we move into the trial phase?
No, Judge.
All right, then you may proceed. And I don't know what specific discussions you all had about the stipulations as far as Mr. Doji is concerned. But I'm going to let you kind of decide what all you need to put on the record based on the conversation you all had.
Thank you, Judge. Yeah, I was going to call Ms. Nix and still have her testify regarding those issues, Judge.
Okay, then you may proceed and address each parent in whatever order you see fit.
Thank you, Judge. Are you the permanency specialist that's assigned to Cassius's case?
Yes.
Okay. The court just submitted petitioner's exhibit number 12, which was the affidavit of voluntary relinquishment for Ms. Gonzalez. Do you remember seeing that document?
Yes, I do.
Okay. At the time that Ms. Gonzalez executed that document, was she represented by an attorney?
Yes, she was.
Did she have the opportunity to review that document with her attorney prior to its execution?
Yes, she did.
Is it your understanding that Ms. Gonzalez was able to have all of her questions answered regarding that document?
Yes.
Do you believe that Ms. Gonzalez executed that document knowing the legal ramifications of it?
Yes.
Did the department threaten Ms. Gonzalez in any way in exchange for that document?
No.
And did the department promise Ms. Gonzalez anything in exchange for that document?
No.
Do you believe that Ms. Gonzalez executed that document freely and voluntarily?
Yes, she did.
And she did so believing that execution of that document was in the best interest of her son Cassius.
Yes.
Are you asking the court, based off the Rule 11 agreement that was previously read into the record, to terminate Ms. Gonzalez's relationship with Cassius based solely off that relinquishment?
Yes, I am.
And based off the fact that it's in Cassius' best interest?
Yes.
Okay. During the course of this case, Mr. Doji was adjudicated as Cassius' father. Is that correct?
Yes.
And prior to that adjudication, was there a family plan of service that was created for Mr. Doji?
Yes, there was.
And are you familiar with what was required of Mr. Doji in that family plan?
Yes.
Okay. Was Mr. Doji required to complete random drug testing?
Yes.
At any point in time during the course of this case, did Mr. Doji complete any of that testing?
No.
Okay. Well, let me back up. Did you have contact with Mr. Doji since becoming the primary caseworker on this case?
No, I was assigned the case in December and I have not had any contact with Mr. Doji.
Okay. And what attempts did you make to establish contact with him?
Shortly after the case was assigned to me in December, January, February, and in March, and one more time in April, I made attempts to go to the only address I had for him, which was the apartments here in Bernie on River Road. Sometimes people did not answer the door. Sometimes they did. When anybody ever answered the door, I handed them my card, told them who I was, and that I really needed to speak with Mr. Doji. If nobody was there, I just left my card in the door. And my last attempt to see him in person was in April, and that's when a person who believes is his mother told me that he was in jail in Bexar County. I attempted to facilitate a virtual visit, but wasn't successful with that.
Okay. And throughout the course of the case, did the department make efforts to contact him and locate him?
Yes.
And in fact, Mr. Doji actually, he signed a waiver of service in this case where he provided his address and phone number. Is that correct?
I believe that was one of the exhibits, yes.
Okay. And did you have a phone number for Mr. Doji that you tried to contact him at?
I did not try to contact him by phone. I just kept going by the apartment and leaving my card.
Okay. During the course of this case, or actually, let me ask you this: what other services was Mr. Doji required to complete under his family plan?
In my review of his family plan of service, there was a psychosocial requested following the recommendations of his therapist, individual therapy, the drug testing that you already mentioned. As outlined in the family plan, once he took a drug test, if he tested positive, he was supposed to submit to a substance abuse assessment to secure stable employment and stable housing, as well as completing a psychological and a parenting class.
Okay. And did Mr. Doji engage in any of those services throughout the course of this case?
No.
Okay. Has Mr. Doji had any contact with Cassius?
No.
Did you make attempts, or were you willing to offer Mr. Doji contact with Cassius if he would have completed or engaged in his family plan?
If I could have had any contact with them at all, we certainly would have discussed visitation.
Okay. And has Mr. Doji ever reached out to you to check on Cassius to see how he's doing?
No.
Did Mr. Doji ever reach out to you to engage in his family plan of service?
No.
Can you give the court an update on where Cassius is currently placed?
He's placed in a licensed foster home here in Bernie. He's been there for 10 months.
Okay. And how is he doing in that placement?
He seems to be doing very well. I just saw him maybe a week and a half ago. He's thriving. He's healthy. He's just about on the verge of walking, appears to be meeting his developmental milestones. He's doing very well, very healthy and robust.
Okay. Have you had the opportunity to observe the relationship between Cassius and his foster parents?
Yes, I have.
And can you describe the relationship that you've been able to observe for us?
Yes, he appears very bonded with them. You can see when you're in the home, if he needs comforting, those are the two people that he looks to comfort when or to meet his needs. He's frequently makes eye contact and laughs when they're talking to him. And you can see even with his being a year old that he's quite bonded with both his foster parents.
Okay. Does Cassius have any special needs at this point?
No, he had some struggles when he was first born. And then when he arrived at the Quins, problems with exceptional spitting up and gastroenterology problems. And he was seeing a specialist, but I believe he's been discharged from those services and seems to have recovered and is not having those issues any longer.
Okay. And were the Quins able to take him to all of his appointments to make sure that those needs were met?
Yes, they made sure that he had all of his needs met and saw all the specialists that he needed to.
Okay. What is the current permanency goal for Cassius?
It is for Mr. and Miss Quinn to adopt Cassius.
Okay. Have they expressed a desire to adopt him?
Oh, indeed they have.
Okay. Are there any specific barriers to being able to achieve that permanency goal after the trial is completed?
No, there are no known barriers to adoption.
Okay. Do you believe that it's in Cash's best interests for his relationship with both of his parents to be terminated today?
Yes.
Can you just briefly describe why you think that's in his best interest?
Because Cassius has been in basically the only home he's known for 10 months out of his a little over 1 year of his little life. It creates a pathway for him to be adopted and to find permanency in a forever home.
Okay. Pass the witness, Judge.
Mr. Fuller?
Ms. Nix, were you able to sign the affidavit of relinquishment that was executed by my client?
Not yet.
Yeah, you did.
Did I?
Yes. Sorry. In the affidavit was you were at the Comal County Jail when the affidavit was executed, actually. You
That's
remember that?
true. I met you. I was going in as you were going out.
Okay.
It's been a while.
It had. And do you feel that Ms. Gonzalez made this decision with her son's best interest in mind?
Yes, I really do believe that, and I know she's doing it for that very reason.
And based on your interactions with the foster home, do you feel that they will be willing to follow the Rule 11 agreement and maintain contact with Ms. Gonzalez?
I have every confidence that Mr. and Ms. Quinn will make every effort to maintain contact with the family. They've done a good job of that so far throughout this case, probably an exceptional job of any case I've ever worked over. They've done a lot to involve the family, and I have every reason to believe they'll continue to do that.
And in fact, they provided visits with the siblings and the cousins, correct?
They have, and pictures and updates, and I think they've done exceptional in that area.
Okay, and you have no concerns whatsoever about this place?
I do not.
Pass the witness.
Mr. Weatherby?
No questions, Your Honor.
Mr. Salvar?
Yes. Do you believe that this agreement is in Cassius's best interest?
Yes, I do.
And the home is they're currently licensed to adopt. Is that correct?
Yes, they are a licensed foster home.
Okay. And throughout this case, they've met all his needs?
They have.
And do you believe that this home is, for him staying in this home, is in his best interest?
Yes.
Okay. And is Cassius bonded to this placement?
He is very bonded with them.
Okay. And in your opinion, does he see them as his mom and dad?
At a year old, it's hard to say that, but he certainly sees them as the people who are going to help him when he needs help. So when he wants something, that's who he looks to.
Sounds good. Pass the witness, Judge. Thank you.
Anything further from the department?
No, Your Honor.
Anything from anybody else besides reports?
Your Honor, I'd like to call my client.
All right, Ms. Fuller, you may call Ms. Gonzalez.
Ms. Gonzalez, can you please state your full name?
Nicole Marie Gonzalez.
And you saw that we have admitted the relinquishment that you executed, correct?
Correct.
And we went over that relinquishment page by page, did we not?
Yes, ma'am.
And you initialed each page.
Yes.
And do you feel this is in the best interest of your child at this time?
I do.
And is there anything else that you would like to say to the court?
Not at this time.
I'll pass the witness.
Anybody else have any other questions for Ms. Gonzalez?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, Mr. Saldivar.
Judge, I believe that this agreement is in Cassius' best interest. He's been with this family for a while now. He's bonded. They are ready and willing to adopt him, and they are. I have no doubt that they'll continue to supply pictures and updates to mom. In this case, I believe this is in the best interest, and this will meet his needs going forward.
All right, Casa, Ms. Weber.
Can you hear me, Your Honor?
Yes, I can.
Better? Okay, good. CASA's in complete agreement, of course, also with Cash staying with the Quinns and looking forward to the future adoption. He's done very well. Every visit has been shown how well he's bonded to the family, and he is just such a delightful little boy. He's ready to be adopted.
All right, thank you. Anything further from anyone else?
No, Judge.
Okay. For the purposes of the final trial, court finds that all parties entitled to citation and notice were duly cited and served and or otherwise have appeared in this hearing today by and through counsel and made a general appearance. Court finds that the court has continued exclusive jurisdiction of the child of this suit, that no other court has continued exclusive jurisdiction, or there's no evidence suggesting any other court has continuing exclusive jurisdiction. The court has jurisdiction over the subject matter and the parties. Court finds that the department has proved by clear and convincing evidence pursuant to Chapter 161.001B1K that the mother, Nicole Gonzalez, has, on or before this suit was filed, executed a voluntary affidavit of relinquishment. The court also finds that the department has proved by clear and convincing evidence pursuant to Chapter 161.001 B1N that the father, Derek Doge, has constructively abandoned the child who's been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 6 months, and the department has made reasonable efforts to return the child to the parent. The parent is not regularly visited or maintained significant contact with the child, and the parent has demonstrated an inability to provide the child with a safe environment. And 161.001B10, in that the father has failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse and neglect of the child. Court further finds that in addition to terminating on these grounds, the court finds it's in the best interest of the children or the child to terminate the parental rights of the mother and the father. Court finds that it's in the best interest of the child to name the Department of Family Protective Services / belong as the permanent managing conservator of the child. Court finds it's in the child's best interest to maintain the appointment of the child's attorney ad litem, Richard Saldivar, and the child's guardian ad litem, Country Casa. The court will dismiss Deborah Fuller and Mr. Weatherby as parents, attorneys, and find that they have satisfied all their duties. We're going to have a permanency review after final order September 11th at 9:30. September 11th, 2024 at 9:30. One other thing I wanted to put on the record was that the exhibits included two things. The paternity registry search certificate as Exhibit 4, and then a adjudication of the father as the adjudication of Mr. Dozie as the father as petitioner's Exhibit 11. I'm assuming, Mr. McKeska, that petitioner's Exhibit 11 would make any finding or termination of unknown father moot, correct?
That's correct, Judge.
All right. I just want to throw that up in the record so that we're all on the same page. All right. Anything I have failed to address?
No, Your Honor.
All right, Mr. Doji and Ms. Gonzalez, I understand that you made some agreements today that may not have been very easy to make. I think you're doing the best thing for your child. I appreciate the decision that you made. Everybody else that's been on this case, thank you for your time and your service. And if nothing further, all parties are excused.
Thank you, Judge.
Hey, Mr. McCusker, will you
Yes.
send those exhibits to Miss Greenwald,
Do you all need
please?
to confer
Yes, ma'am.
before we move forward?
I don't think it would hurt, Your Honor.
Is there any sort of agreement in place at this point in time, or are we looking at a contested hearing?
I have not received an answer to the email, so I don't know, Your Honor.
Judge, this is Quincy Brandon for the mom. We're in agreement. Sorry, I forgot to respond to your email. I responded to somebody else's email on it, but I forgot to respond to yours. I'm sorry.
I'm sort of new, Judge. They're getting used to me temporarily.
Well, as soon as I get used to you, we're gonna lose you.
May I ask, is it pronounced Quincy?
Yes, ma'am.
Thank you, sir.
All right, Mr. Rudkin, have you had a chance to talk to your client?
I have not. I've had some issues getting in touch with my client, and I don't even know if he's logged on right now.
I think is that him sitting there with you, Miss Harnack?
Yes, sir.
Okay. Sure, I can confer. I can confer with my client. Sure.
All right, I'm gonna put you and your client in breakout room 2.
Sure. Thanks.
And I'll put everybody else in breakout room 1, and then we can move people around as we need to. Do we need, you know what, she's here. Miss Jackson, could you go ahead and take a record of this for me, please?
Yes, sir.
Thank you. With that, Miss Rush, would you please begin the announcement?
Ursula Rush and Jennifer Simmons for the department, ready.
Jennifer Simmons, family-based caseworker with the department. Carol McKetta, family-based supervisor.
Kurt Rudkin, attorney for the father, Brandon Carrillo.
Quincy Brandon, attorney for the mother, present, ready.
Kathleen Savage, attorney ad litem for the children, Your Honor, I'm ready.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the children.
Can I get both the parents to announce, please?
Stephanie Harnack.
Brandon Carrillo. All right. I show in my system that both parents were served. Mr. Carrillo was served June 14th by waiver, and Ms. Harnack was served June 5th by waiver. The parties have been able to confer. Ms. Rush, do we have an agreement?
Yes, sir, we do.
All right. Could you give me the terms and conditions of the agreement, please?
The department will be named temporary managing conservator. I do have to ask the court for a chance to put Mr. Carrillo and Ms. Harnack on the stand to prove up paternity of Serenity, since he is an alleged father. Assuming he is found to be the father of Serenity, both parents will be named temporary managing conservator of both children. There'll be the standard orders as issued by the Child Protection Court of Bandera County. The parents will get, since they are a couple, they will get 1 visit a week for an hour together in Bandera, and will be required to provide their own transportation. I believe, I'm sorry, Your Honor, I forgot to ask, and I'm looking right now. I don't know if they have both filled out child caregiver resource forms, but it'll take me just a second. I don't see that I have the child placement forms, but I don't get everything that gets e-filed. Obviously, if they've not filled them out, we'll ask the court to order those be filled out. The placement will remain with the relative, and the visitations in Bandera will be supervised by Belong. Does the court need to know anything else?
I think that's it.
Thank you, sir.
Mr. Brandon, is that your understanding of the agreement?
That is my understanding, Judge.
Mr. Rudkin?
It is.
Ms. Savage?
Yes, Your Honor, it is.
Casa?
That's my understanding, Your Honor, with one addition. We were seeking daycare for the children because the grandmother works outside of the home and the grandfather is disabled. The placement is very remote, and I would like to see the children have regular contact with other children to work on their social and developmental interaction with peers their own age.
And Your Honor, I apologize. Part of the agreement was that we would ask the court to order daycare be paid for by the belong.
Okay, thank you. Ms. Harnack and Mr. Carrillo, you both heard the agreement that was stated on the record?
Yes.
Mr. Carrillo, I need you to answer out loud. Did you hear the agreement?
Yes, sir.
All right. Did you both understand the agreement?
Yes, sir.
Sure.
Yes.
Oh, yes, I did.
Do you both understand what's expected of you out of this agreement?
Yes, sir.
All right. Did you both have an opportunity to discuss it with your attorney?
Yes.
And do you both, were either of you made any promises or inducements to get you to agree to this, or were you forced to agree to it?
We weren't forced, no.
Okay. So you're both asking the court to approve your voluntary agreement to these orders today?
Yes.
Okay. Ms. Simmons, do you believe that this agreement is in the best interest of the children?
Yes, I do.
And was this based off your affidavit?
Yes.
And to your knowledge, today is everything that was in your affidavit filed with the petition still true and correct?
Yes.
All right. And do all of the parties stipulate to the reasonable efforts made by the department to avoid a removal and to return the children home in this case?
Yes, sir.
Yes, Your Honor.
Yes, Your Honor.
Okay. The court will adopt and approve the agreement of the parties. Court finds there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. Reasonable efforts have been made to enable the child to return home, but there's a substantial risk of continuing danger if the child is returned home. Ms. Simmons, is there any Indian child heritage in this case?
There is not.
And where is the child's placed with the grandmother?
Yes, with the maternal. Yeah. Yes, sir. Maternal grandparents.
What county?
Bandera, but they live in Utopia.
And what was the date of placement there?
The June 5th.
And is that placement safe and appropriate, meeting their needs?
Yes.
And is it in their best interest to remain there at this time?
Yes.
Do we have any specific urgent needs for the children at this time?
Other than what the daycare being mentioned, other than that, no.
Okay. Well, the court will adopt and approve the agreement of the parties and name the Department of Family Protective Services as a temporary managing conservator, name the parents as temporary possessory conservators. Miss Rush, I think before you wanted me to make that designation, you wanted to take up some testimony from the parents regarding paternity.
Yes, please.
All right, please go ahead. Call your first witness.
Department calls Stephanie Harnack.
All right, Ms. Harnack, I need you to speak up really loud so we can get this on the record, please.
Okay.
RUSTEPHANIE. And Mr. Carrillo is the legal father of Serenity. Is that correct? I'm sorry.
Yeah.
I'm sorry. Do you believe and swear under penalty of perjury under oath that Brandon Carrillo is the father of Serenity?
Okay.
And you do not require a DNA test at this time, correct?
No.
Okay. You are also the mother of ALLI.
Yes.
And apparently Mr. Carrillo is the presumed father. He signed something at the hospital. Is that correct? Okay. Pass the witness.
Mr. Brandon.
Yes,
No
sir.
question.
Yes, sir.
Mr. Rudkin,
Questions?
Ms. Savage,
No questions, Your Honor.
any other witnesses?
Mr. Carrillo?
All right, Mr. Carrillo, Miss Rush is going to ask you some questions. You've been sworn. You need to remember to answer loud and clear so we can hear you.
Sir, are you Brandon?
Yes, ma'am.
So there are two R's in your name.
Yes, ma'am.
Okay. And do you swear under penalty of perjury that you are the father of Serenity, do not require a DNA test?
Yes, ma'am.
And I should have asked Stephanie, and I forgot, but I'm sure you know, is Stephanie currently married, or was she married legally to anyone when Serenity was born?
No.
Okay. And Mr. Carrillo, you signed something that made you the legal father of ALLINIT.
Yes, ma'am.
How do you pronounce that?
Alinity?
Okay. Pass the witness.
Any other questions for Mr. Carrillo?
No, Your Honor.
No.
Mr. Carrillo, are you asking the court to name you as Serenity's legal father today?
Yes, ma'am.
Pass the witness, Your Honor.
All right, Mr. Carrillo, I'm going to ask you a few questions too, because the testimony that you're giving today, if the court orders what the department has alluded that they're going to ask me to order based on your testimony, it's not going to be undone. It's permanent. And I read the affidavit in this case, and I understand what the allegations were that brought us here. And I'm going to ask you a very pointed question, and I want a very pointed answer. Okay. Are you under the influence of anything right now?
No, sir. I can't concentrate right now. Sorry.
Okay. Why can't you concentrate right now?
Because my air conditioner making noises that I don't want y'all. I mean, just trying to be cordial.
Okay. So you're telling me that right now, as we sit here, you're not under the influence of any substance? You're not under the influence of alcohol?
No, sir.
Are you tired?
No, sir.
Okay. Anybody have any other questions?
No, sir.
Ms. Rush? No? Okay. All right, then, Ms. Rush, I don't want to put words in your mouth, but my assumption is that you want the court to adjudicate based on the testimony.
Yes, sir.
Any objections?
No.
No, Your Honor.
No, Judge.
All right. Then based on the testimony and the argument of counsel, the court will find that there's evidence to support a finding that Mr. Carrillo is the biological father of Serenity, and court will adjudicate him for all intents and purposes as to that request. In doing so, then the court will name both Ms. Harnack and Mr. Carrillo as temporary possessory conservator parents of these children, and we'll order they have one visit per week for 1 hour together. I'm going to order that the parties attend a family group conference to develop a family plan of service. I'm going to order the parents to fill out the child caregiver resource form and order the parties to develop family plans of service that are narrowly tailored to address the concerns that brought the children into care. I'm going to order Belong to assist with the daycare for Miss Rosalinda Harnack and her husband, which is placement. We're going to have a status hearing on July 12th, 2024 at 11 a.m. July 12th, 2024 at 11 a.m. Mr. Carrillo and Ms. Harnack, I have to tell you that the state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home. If you cannot do that within 12 months, your rights to your child will be subject to restriction as they are now or terminated. Okay? When we come back on July 12th, my hope is that we hear that you have been engaging with your caseworker and your attorneys and trying to get things done and move this case along, because a year goes by really fast. If we come back on the 12th and I don't hear that, and I hear that you haven't been making contact with anybody, you haven't been cooperating, or you haven't been engaging in things, then these orders could be subject to change at some point. Things could get more difficult. So I strongly encourage you to make sure you understand what you need to do and to stay in contact with the people involved in this case so that you get it done. Okay. Ms. Rush, is there anything I failed to address?
I don't believe so. Thank you, sir.
Your Honor, I just had one question. I was wondering if the home study for the maternal grandparents had been submitted.
Is anybody aware?
I did the preliminary home assessment, and then I believe Belong was working on sending off the full home study.
If not, if I can ask for an expedited home study, Your Honor, to be included in the order. The daycare order will be its own standalone order I can submit to the court. And then I didn't know if the court wanted to take information from the parents to keep the parents' attorneys appointed.
Oh, yes, I did. And thank you for the reminder. Okay, I'm going to go ahead and expedite that home study. And then Mr. Carrillo and Ms. Harnack, do either one of you have the ability to afford an attorney in this case?
No.
You do?
Yes, sir. No, sir. I have a couple of friends that are lawyers that could be a counsel, but I don't have none on standby like right now.
Well, my question to you is, do you have the funds necessary to pay for an attorney to represent you in this case?
Yes, sir.
Okay. I'm going to ask you a few more questions. Let me talk to Ms. Harnack first. Ma'am, you said that you do not have the funds available?
No.
Do you have anything you could sell that would help you to pay for an attorney?
No.
Do you have any money saved up at all, or anything at all that would help you pay for an attorney?
No.
Do you receive governmental assistance?
Just WIC.
Okay. For the purposes of this case, the court will maintain that Ms. Harnack is indigent and keep Mr. Brennan on as her court-appointed attorney. Where did Mr. Carrillo go?
Your Honor, if I could ask that for Mr. Carrillo, we kick this to status and give Mr. Redkin some time to ask him his financial information. There was an issue of an ED earlier in this case. I just want to make sure that's accurate.
Okay. I do believe that I think it would be appropriate for Mr. Rudkin and Mr. Carrillo to talk. So I will abate an indigency finding to the status hearing so that Mr. Carrillo can get a true understanding of what it would be for him to hire retained representation in this case.
Okay.
Anything else?
No, Your Honor.
Okay. Thank you all for your time and your service. If nothing further, all parties are excused. That concludes our docket for today.
Thank you.
Have a nice
Good
evening.
weekend.
Thank you.